Well, with the expiration of their tenures, 13 of them resident electoral commissioners, with 8 out of the 13 already nominated. The question is, how best can we get them nominated and subsequently approved? My joining us to look at that this time is Chima Nnaji. He's a lawyer and a public affairs analyst. Good to have you join us this morning.
My pleasure. Good morning.
You know, we're trying to look at the Constitution with Dr. Dogo, and well, he says whatever the president has done is in line with the Constitution. But away from all of that, is that the best way to go about it?
Well, the basic place to start is from the basic law. If it is consistent with the law, if you have done anything consistent with the law, then any further statement on that conduct will be an embellishment. For example, the call by the opposition that it should have been done differently, perhaps by advertising and all that. They're exercising their constitutional right. It is within their right to make that call. Otherwise, there will cease to be opposition. To be constructive opposition, you have to look at what the party in government has done differently and prefer what you may consider a superior form, consistent with the law, within which that same act ought to have been done. But then, you also look at the opposition parties generally. Some of them that have been able to form government have also constituted state independent electoral commissions in their various states. What is good for the goose, they say is also good for the gander, isn't it? So they should also look at the process by which those people that constitute those bodies were, nominated and appointed. It's not just a question of excuse me. There is need for transparency. There's no doubt about it, at all levels of governance in this country. Now, it is not so much about what the law says, but what do people perceive? Because something might be rooted in constitution, and there's so much talk about constitutionalism when that narrow act favors a certain narrow group. Okay? So we shouldn't be so much bothered about that. In as much as as a lawyer, I would want governance to take place within the ambit of the law. It makes life easier. But then some people in jurisprudential level will ask, who made the law? And what was the end of that law? Such that when you're now citing it to justify your action, it probably was just a case of self-fulfilling prophecy. So what we are now looking at is expression of sentiment by opposition parties.
Do you think you're just making noise for the sake of making noise? I mean, you said that there will not be opposition if they did not object to certain things that the government did. But you think they're just making this noise for the sake of it?
I wouldn't want to call it noise. They are doing their job. The position changes when you move from the passenger seat in a car to driver's seat. You don't get to see all the masquerades on the road and their features. You definitely see a masquerade crossing, but you may not know whether it has about rainbow colors. It is the passenger who goes for those details. Your business is to focus on what constitutes an impediment on your driving. Okay. Now, the issue in this instance is that those parties in the opposition that also have got the opportunity to demonstrate good governance in the states have not done otherwise. I don't know whether I'm communicating. So the issue is that sentiment itself fizzles when you now bring to fore the practices at the state level. Because we are talking about Nigeria, a federation, governed by laws. So that state government run by some of the parties that are making the calls or other calls should also examine their own processes. Equity demands that they must look good before they begin to talk to somebody else.
Okay. I asked this question to Dr. Dogo, and I ask it again. Do you think the political class is interested in political reforms, really interested in political reforms?
I think they might be interested in political reforms,
But
not the type that you and I probably would, change is a constant phenomenon.
Okay, I ask that question because there's the opposition that you say is doing their job actually mentioned only one name. Yes, they complained about the others, but they mentioned one name. 1999 to 2003 Speaker. Then REC 2007, Benway, the one that came up that the election that the Senate President won, which was a case of taken to the petition to the tribunal, then the Delta rerun to January, and then the elections in Delta again. That one man seemed to have had issues around the elections he has conducted, but he's also brought in there. What does that say of the administration?
Well, if they have singled out one single person and given all these antecedent data about him or facts about him, I think it should be looked at from that context. The mere fact that you are even a card-carrying member of a political party does not necessarily make you biased towards that party if you are given a particular critical role. We as individuals are governed by the rules we play. Here now you are a journalist. At home you are a father, or a brother, or a son, or a daughter. You understand? And you play these rules in very distinguished manner, without any conflict, if you have integrity. And that is what the Constitution says in appointing a REC. Apart from the age definition there, the next thing is integrity. That somebody who has integrity. There are so many people who do not have cards of any political party. They are more political, more biased towards certain political parties than even the people who are enjoying certain fruits of that particular political party. How dangerous could those people be? The role, what I foresee in a situation like this, if you have a card-carrying member of a political party so appointed, it doesn't have to be PDP. Let's face it, it doesn't have to be PDP. If you are a card-carrying member, it is even so much a responsibility on you to establish, because you are guilty ab initio. You are not going to prove yourself innocent. But in this singular case of the man that you just mentioned, if he has failed the test, it's a different thing. I don't know whether you get. And we have to examine very carefully whether petitions were just raised against him because somebody wants to establish that having been this, he cannot be transparent. I don't know whether you get the point. So these are very critical issues, because we may run into murky waters if we begin to pigeonhole people into those small, narrow, But and then let me make this statement. As long as the Constitution has not been amended, the Section 65 of the Constitution clearly defines what qualification it takes to become a member of the National Assembly, especially the House of Reps. And the Constitution says that the qualification, and it's also repeated in the Electoral Act 2010, the qualification to be appointed, what qualifies you to be appointed a REC is that you must have been qualified to be elected as a member of the House of Representatives. And one critical condition is that you must be a member of a political party. You understand what I mean? So, where does that lead us? Is it not a contradiction?
You remember that has
Is
always
that clear?
That was an issue even last year and the year before, to the extent that people were talking about it being removed when we had that.
It has not been removed.
That little amendment last year.
It has not been removed. In the two amendments,
there is
still much there because, like you asked me whether they have interest in, you know, people look at things. It's just like when you are writing an agreement and the man who is supposed to be under obligation sees a small hiatus in that agreement. He exploits it and dares you to go to court if he sees any little thing to exploit. So this is, they will say, after all, we did not write the Constitution, but we can benefit from that.
No, if truly they try not to look the way of that particular section of the Constitution that
it is there.
Yes, if they decide,
and it must be adjusted.
If they decide not to look to it.
Yes.
Remember what just happened during the nomination of some of the ministers, especially that from Taraba State.
Yes.
Just the way people are kicking against some of these 8 nominee recs is the same way we saw that the entire, almost all the senators and House of Representatives members, on behalf of their constituents, kicked against the nominee from Taraba State, and the government listened, even though the prerogative lies with the president to do all of that nomination.
Yes.
Can we also see that in the light of what happened during the ministerial nomination and say, let's see how best we can satisfy some section of those people and assuage their fears by looking elsewhere?
You see, this is not a do or die appointment. Just like some people would say, in the case of Obasanjo in the days of Aborishade, is it Aborishade? You throw him out, you bring him back, and people were going, is there anything? So the issue here is, if there are some facts, like Nato had reeled out, these people say this man was this man was. It is not so much because he was that I will be persuaded that he should be dropped. It is that there is a track record that perhaps, even though he has been this, it appears that has colored his perception of the criticality of his duty.
Okay, well,
you understand?
Yeah.
Only to the extent, however, again, that we are able to determine that those petitions were not necessarily to indict him,
okay,
to color him, okay, within the narrow interest of the group that perhaps may have engineered it.